If you are over 65 and you have money in a bank or brokerage account, there is a law on the books right now that allows your bank to freeze your account for up to 55 business days without your permission and without you having done a single thing wrong. Most seniors have never heard of it. Your bank is not going to explain it to you. This video will. Barbara had been a school teacher for 31 years. She retired at 66, paid off her house, and lived carefully on a combination of Social Security and a modest pension. She was not reckless with money. She was not confused. She was sharp, careful, and responsible. So when she called her brokerage one afternoon to move $12,000 to cover a roof repair, she expected it to take about 10 minutes. Instead, the transaction was flagged. Her account was frozen. Not because she did anything wrong. Not because anyone stole from her, because a computer algorithm decided her request looked unusual. The hold lasted 11 business days. During that time, she could not access her own money. She almost missed the contractor's deposit deadline. Nobody from the firm called her first to ask if she was okay. The freeze just happened. What Barbara did not know is that under a federal rule that applies specifically to people 65 and older, her brokerage had the legal right to do exactly that. And more importantly, she did not know the steps she should have taken before that phone call that would have prevented the entire situation. If you have a bank account, a brokerage, or any kind of financial account, you need to watch this video to the end. The last item on this list is the one most seniors never reach, and it is the one that matters most. In the next several minutes, you are going to learn exactly why this is happening to seniors across the country right now, who has the authority to freeze your money, how long they can legally hold it, and the exact steps you take today to protect yourself. If you find this channel useful, hit the button below. The rules around your money change every single year. The government does not send you a letter when they do. This channel does the work, so you do not have to. Here is what most people do not understand. Banks and brokerages have been freezing senior accounts at a rate that is rising every year, and the legal framework behind it has been quietly expanding since 2018. The Department of Justice estimates that $3 billion is stolen or defrauded from elderly Americans every single year. That number pushed regulators to act. And the tools they gave financial institutions are powerful. The problem is that those tools do not always distinguish between a scam and a grandmother paying her roofer. In 2018, the Financial Industry Regulatory Authority, known as FINRA, adopted Rule 2165. That rule gave broker-dealers and financial firms the legal authority to place a temporary hold on transactions and fund disbursements from the accounts of any customer 65 years or older. The rule was designed to protect seniors from exploitation. That is a legitimate and important goal. But the rule also gave institutions what is called a safe harbor, meaning they are legally protected from being sued by you for freezing your money if they believed in good faith that something was wrong. That immunity changed everything. Before 2018, banks were hesitant to stop your transactions because they feared being sued for wrongful denial. After 2018, that fear went away. And in the years since, more than 30 states have passed additional safe harbor laws that extend this authority to regular bank accounts, not just brokerage accounts. In 2026, these systems have gotten more aggressive because the tools behind them have gotten more powerful. AI platforms now build a model of your normal financial behavior and flag anything that deviates from it automatically. The hold goes on before any human being has looked at your account. Nobody sent you a flyer about any of this. Your bank did not call you to explain what changed. Financial institutions are not required to educate their customers about the rules that govern what the institution can do to them. The gap in your knowledge is not your failure. It is a structural feature of how this system works. And that gap is exactly what this video is here to close. Before we go further, two things need to be said. First, this is not only a problem for people with large accounts or complex finances. Barbara had a straightforward brokerage account and a routine repair to pay for. It happened to her. It can happen to anyone over 65 with any kind of financial account. Second, this is not about banks being dishonest. The rules behind these freezes were created in response to a real and devastating problem. But good intentions and blunt instruments are a difficult combination when your rent is due and your money is locked. Now, here is what you actually need to know. The first thing to understand is how the hold system works and how long your money can legally be kept from you. Under FINRA Rule 2165, when a financial firm decides a transaction looks suspicious, they can place a temporary hold that initially lasts up to 15 business days. Business days, not calendar days. 15 business days is 3 full weeks. If the firm conducts an internal review and still has concerns, they can extend that hold by an additional 10 business days. That is now 5 weeks, your money is inaccessible. And if the firm reports the matter to a state agency like Adult Protective Services or to law enforcement, they can extend the hold further still, to a total of 55 business days. That is 11 full weeks, nearly 3 months. For a retiree on a fixed income who needs that money to pay a contractor, cover a medical bill, or make a car payment, 55 business days is not a minor inconvenience. It is a financial crisis. What most seniors do not realize is that the hold does not require proof that you are being exploited. It only requires that the firm has a reasonable belief that exploitation has occurred, is occurring, has been attempted, or might be attempted. That is a broad standard. An algorithm that sees you wire more money than usual, or send a transfer to a person it has not seen before, can generate that belief automatically. The system is not malicious, but it is blunt. And if you do not know how it works, you are not prepared for it. The first protective step is simple, free, and you can do it this week. Call your bank and your brokerage and ask them to document your regular transaction patterns. Tell them that you may periodically make large transfers for home repairs, medical expenses, or gifts to family members. Ask them to note this in your account file. This does not prevent a hold from ever being placed, but it creates context that a human reviewer can see when your account gets flagged. A transaction that looks suspicious in the absence of context looks routine when the context is there. But that is not the one that surprises most people. Here is what comes next. The second thing you need to know is what a trusted contact person is, and why not having one on file right now is leaving you exposed. Under FINRA Rule 4512, every brokerage firm is required to ask you to designate a trusted contact person when you open an account or update your account information. A trusted contact person is not a power of attorney. They do not have authority over your money. They cannot make trades or withdrawals on your behalf. What they can do is receive a call from your firm when the firm suspects something is wrong, help confirm your contact information or health status, and in many cases help resolve a hold faster by vouching for your intent and your circumstances. The problem is that many seniors never filled this out. Maybe you opened your account before the rule took effect in 2018. Maybe the form was buried in routine paperwork and nobody explained what it was for. If you do not have a trusted contact person on file, your firm has no one to call when a hold is placed. That means the hold process runs entirely through the institution's internal review with no outside voice speaking on your behalf. It is slower, more impersonal, and more likely to extend to the maximum allowed period. Here is what you do. Call your brokerage or bank this week and ask specifically whether you have a trusted contact person designated on your account. If you do not, ask them to send you the form to add one. Choose someone you trust completely, whether that is an adult child, a sibling, a close friend, or an attorney. This one step can shorten a hold significantly, because the firm has a named person they are authorized to contact and who can speak to your normal behavior and intentions. And here is where it gets more interesting. The third area most seniors are not prepared for is what AI behavioral profiling actually looks like in practice and how easily it can flag your account. In 2026, banks and brokerages are no longer relying on simple dollar thresholds to detect suspicious activity. They are using artificial intelligence platforms that build a detailed model of your financial life, where you shop, when you log in, how frequently you make transfers, what amounts you typically move, who you send money to. This model is updated continuously. When your behavior suddenly deviates from that model in any significant way, the system flags the deviation and a hold can be placed automatically before any human being has reviewed the situation. This creates specific problems for seniors in recognizable situations. If you have been using only a debit card for years and you suddenly try to wire $10,000, the system treats that as an anomaly. If you have never used a peer-to-peer payment app and you start using one to send money to a grandchild, the system can read that as behavior associated with coerced transfers and scams. If you typically log in during the morning and your account is accessed at 11 at night, even if you were the one who did it, the system notes it as a deviation. None of these things mean you are being exploited, but the algorithm does not know that. And the algorithm acts first. The hold goes on. Then a human reviewer is supposed to follow up. But the reviewer starts from the assumption that the flag was valid, not from the assumption that you are a competent adult making a normal financial decision. The protection here is proactive communication. Talk to your financial institution about your anticipated activity before it happens. If you know you are going to make a large purchase, complete a wire transfer, or send money to a new recipient in the next 30 days, call your bank ahead of time and tell them. Ask them to note the conversation in your account file. Banks are not legally required to accept this kind of advance notification, but most will document it, and documentation changes the outcome when a flag goes up. This next one is the one most seniors never reach because they stopped watching at the first item, and it may be the most important of all. The fourth thing you need to understand is your rights once a hold is actually placed. If your account is frozen, you are not powerless. The hold under FINRA Rule 2165 is supposed to apply to the specific disbursement or transaction that triggered concern, not to your entire account and all its activity. Regular established payments, things like monthly utility bills on autopay, your Medicare premium, your regular Social Security direct deposit, are generally supposed to continue. The hold is targeted at the flag transaction. If a hold has been placed on your account and your routine payments are also being blocked, that may be an overreach of what the rule actually permits. You have the right to push back. Ask to speak with the firm's compliance department directly, not a general customer service representative. Ask for the hold notice in writing. Under FINRA Rule 2165, the firm is required to notify you and your trusted contact person about the hold and the reason for it within 2 business days of placing it. If you have not received written notification, request it immediately and document when you made that request. You also have the right to contact your state's financial regulator. Every state has one. A quick search for your state name plus Office of Financial Regulation or Division of Securities will give you the right contact. If you believe a hold has been placed in error or extended without proper justification, file a complaint. This creates a formal record and often accelerates the firm's internal review process because regulators asking questions gets attention inside these institutions in a way that customer calls sometimes do not. What comes next is something most financial advisors will not bring up unless you ask directly. The fifth area that trips up seniors most often involves not their own transactions, but what happens when a family member tries to help. This is one of the most common triggers for an account freeze, and it is entirely preventable with the right documents in place. If a family member calls your bank and says they need to access your account because you are in the hospital, that call is a red flag regardless of who is making it. Banks are trained to treat third-party access requests as potential exploitation, because in many cases that is exactly what they are. Even if the person calling is your own adult child and their intentions are completely honest, the bank is going to hesitate. They may freeze the account pending documentation. And if you never set up the right legal documents in advance, your family may be waiting weeks while an internal review runs its course. The document that prevents this situation is a durable power of attorney. A durable power of attorney designates someone you trust to act on your behalf if you become unable to do so yourself. It is a legal document. It must be prepared properly under your state's law to be valid. But presented to a bank, it changes the entire conversation. Your designated person is no longer a third party making a suspicious request. They are your legally authorized representative, and the bank is required to work with them. If you do not have a durable power of attorney, this is worth a conversation with an elder law attorney. The cost is modest relative to what it protects. And if you do have one, make sure your bank has a copy on file and that the person you named knows exactly where the original document is kept. The sixth point covers what happens when a report goes to Adult Protective Services without your knowledge. Under the rules that now govern banks and brokerages, institutions that suspect financial exploitation are permitted, and in some states required to report that suspicion to Adult Protective Services or local law enforcement. If that report is made in connection with your account, you may find yourself in a situation where a state investigation is underway before you have even been told your account was flagged. You have rights in this process. If Adult Protective Services contacts you in connection with your financial accounts, you are not required to respond without support. You can ask to have a family member, an attorney, or any trusted person present during any conversation. You cannot be penalized for exercising that right. If you receive any indication that a report has been made, contact an elder law attorney as soon as possible. Your state bar association can refer you to one, and many offer a free initial consultation. The seventh item is the one that ties everything together, and it is the only one on this list that is entirely in your control starting today. The single most effective protection is not reactive. It is not waiting until your account is frozen and then figuring out what to do. It is taking 30 minutes this week to complete 4 specific actions before any of this ever happens to you. Call your bank and your brokerage and ask whether you have a trusted contact person on file. If you do not, get the form and fill it out today. Ask each institution to add a note to your account file that you may make periodic large or unusual transactions, and give them brief context for why. Confirm that you have a durable power of attorney in place and that the person named in it knows where the document is and how to use it. Then write down the names of your financial institutions, your account numbers, and the compliance or fraud department phone numbers for each one, and give that list to your trusted contact person. If something happens to you, they are going to need exactly that information to help you. These 4 steps do not require a financial advisor. They do not cost money. They take less time than a trip to the grocery store. And they are the difference between a freeze that resolves in 3 days and a freeze that drags on for 3 months. Barbara eventually got her money released. It took 11 days and 4 phone calls. The contractor was patient. The roof got repaired. But she told her daughter afterward that the worst part was not the delay. It was the feeling of having her own money treated as evidence against her. That feeling is real, and it is not your fault. The system behind these freezes was built in response to a genuine crisis. $3 billion a year stolen from elderly Americans is not a number to dismiss. The protections that gave banks this freeze authority exist because real seniors lost real savings to real criminals. That context does not make the experience of a wrongful or overbroad freeze any less disorienting or damaging, but it does mean the tool itself is not aimed at you. It is a blunt instrument pointed in the right direction that sometimes catches the wrong person. What you can do is make yourself harder to misidentify, not because you owe any institution proof of your competence, but because the steps we walked through today will work for you when the system makes a mistake. And at some point, for a growing number of Americans over 65, it will. Here is what to take from this video. Banks and brokerages now have federal authority under FINRA Rule 2165 to freeze transactions on accounts belonging to anyone 65 or older for up to 55 business days if they suspect exploitation. The freeze can be triggered by an AI system with no human decision required. You have the right to receive written notice of any hold within 2 business days, to know the reason for it, and to contact your state financial regulator if you believe it was improper. And the single most important step you can take this week is to call your bank or brokerage and ask whether you have a trusted contact person on file. This content is for educational purposes only and is not legal or financial advice. Every situation is different. If you are dealing with an account freeze right now or want to put protective documents in place, please speak with a licensed attorney or financial advisor in your state. If this video helped you understand something your bank never took the time to explain, share it with one person you love who is over 65. It could save them weeks of frustration and real financial hardship. That is what this channel is here for.